and you want to represent yourself. I told you I'm going to hold you to the same standards. You will not, by motion, by anything you say, disrespect anything in this court. You understand me? Court does call the case of the people versus Cody Jolly. Your name, sir?
Cody Lee Jolly.
All right. I think this is people's motion.
Yes, Your Honor. I'm handling this for Ms. Willenbring. There is sensitive information in the police report that includes victims' contact information at home addresses and birthdays. So pursuant to the court rule, Ms. Willenbring would like to redact that information from the police report, but is requesting an order from the court for that effect as well.
All right. First thing, Mr. Jolly, let me just, you are going to continue to represent yourself, sir?
Yes.
All right, I just want to...
Right from the start, this case goes in a risky direction. The defendant decides to represent himself. In criminal court, that's almost never a smart move. Yes, judges allow it, but once you go pro se, you're on your own. No help, no shortcuts, no sympathy. One small mistake in this courtroom can cost you years. Watch what happens next.
I advise you that you are charged with that there are 2 counts on your complaint of criminal sexual conduct in the fourth degree by force or coercion. You understand that, sir?
I understand what the charges are, but never.
Okay. Sir, I have to advise you.
Okay.
You understand that?
I understand.
And that those are high court misdemeanors punishable by up to 2 years incarceration, $5,000 fine plus court costs, mandatory HIV and STD testing.
Okay.
You understand that, sir?
Yeah.
All right. Sir, you wish to continue to represent yourself. The court does have to just advise you.
This is where things get serious. The charges may sound complicated, but the impact is real. 2 felony counts involving force or coercion can mean up to 2 years in prison, heavy fines, and mandatory medical testing. This isn't a small charge. This is the kind of case that can change a life forever.
That I will hold you to the same standards as I would hold somebody that is licensed. You have to abide by all of the court rules, etc. You understand that? All right? And that you won't get any favoritism, and that the court is not in a position and will not assist you if there is something that you don't understand. You are going to be charged with knowing court rules and procedure. You understand that?
But I do.
All right. And I would ask you, or I would also tell you that you do have the right, and if you'd like an opportunity to consult with either a retained lawyer or somebody from the public defender's office, the court would make that occur.
Okay.
You understand that, sir? Okay. Do you have a response to the motion from the people?
I mean, my understanding then is they're going to retract the name, the identification of them, but I'll get the rest of the information. Is it correct?
You would get the rest. My understanding is any identifying information other than name,
Okay.
like address, any phone numbers, anything along those lines would be redacted. Do you have any problem with that, sir?
No, I have no use for that.
What I would indicate is that I will grant the motion as filed by the people.
Okay.
And there's also a request, I guess, that the motion hearing will be sealed and preserved for review in the result of an appeal.
I mean, yes, because that's what the court rule says. It's a funky court rule.
It is.
Because I haven't said their addresses or phone numbers out loud. It's just like the court rule says that if we're going to redact, that this hearing then becomes sealed.
Yes, it does. It does say that. So, I mean, I'll order it because that's what the court rule says. However, none of that information has been provided on this record. So the record is clear.
It may not sound exciting, but this part is legally serious. Once a hearing is sealed, it's taken out of public view. The press can't examine it, the public can't question it, and the record is kept strictly for appeals. Courts usually take this step when the risk is high and errors aren't allowed.
Okay, I have a question, Your Honor. Like I said, I have no awareness even of an incident or any conflict occurring at all. I've been obedient I've been good on the tether so far. I talked with Brandon Casey, they're my case manager across the street. He thought that I wouldn't have a problem getting off after the first 30 days here.
I'm sorry?
The tether that I have, I mean, I'm a member. I haven't been in trouble. I've been here for years. I don't have, something I fight, but
So what are you requesting?
that I get this tether off after this over. It's only fair. I mean, I've not been in trouble at all in Ann Arbor ever since I've been here. I've been in trouble at all. Not on probation. I have nothing to do with being a trouble with the community at all or anything like that. No witnesses here. So this is just, we grant that plea.
Given the circumstances, at least as I understand them, and because I haven't heard the entirety of the case or anything,
Right, exactly.
I'm
Probable cause or anything.
I'm going to deny your request. Bond, continue.
Why?
Excuse me? Excuse me? Sir, we're going to have a real problem if you're going to act like that in this court. I want to make it real clear.
And this is the moment everything changes. This isn't about the argument anymore. It's about who controls the courtroom. Judges may allow debate, but they never allow disrespect. One emotional outburst can flip the situation instantly, turning self-representation into a serious risk, where contempt charges and even jail become very real.
I understand you want to represent yourself. I told you I'm going to hold you to the same standards. You will not, by motion, by anything you say, disrespect anything in this court. You understand me? If there is another outburst during any of these proceedings like that in regard to my rulings, I will give you a place to stay. You do not have to worry about having a tether. Am I clear? Am I clear?
Sure.